Tropical storms, flooding, wildfires, drought, shrinking fish catch. In a world of ever-increasing uncertainty, nothing is predictable. The smallest stumble or fumble easily ends in a mighty tumble, with your world crashing down around you. Don't crumble. 𝐀𝐝𝐦𝐢𝐬𝐬𝐢𝐨𝑧 always has your back. 𝐀𝐻𝐿𝐴, we cushion you for life.
Hello, good afternoon. You are welcome to our next edition on 𝐀𝐝𝐦𝐢𝐬𝐢𝐨𝑧 HR Digest. We've brought this your way over a couple of weeks now. I think spanning from about last year into now. Every weekend we bring to your way current and trendy topics, just to throw more light on what is happening in the HR space. I mean, the relationship between the employee, the employer, all that goes on into employment laws, all that goes on into your work as an employer in terms of relationship with employees, what employees expect from you, in terms of their well-being. I mean, a whole lot. We've brought various discussions, various topical discussions your way over the last couple of months. Today we are doing same, and I want to welcome all of you to 𝐀𝐝𝐴𝐦𝐢𝐬𝐢𝐨𝑧 HR Digest. We have just a short space to discuss an interesting topic. What we are bringing your way today borders around the laws on termination in Ghana. I mean, specifically in Ghana. We know we have other people connected from outside Ghana. Again, it's an insightful session for all of us because usually you have like a base where all of us can pick some of these things from. So it's important. Again, if you have the opportunity to even work in Ghana, though you are not a national, you get the opportunity to also get to hear about what our national laws say regarding employer-employee relationship. All right, so I have on the call with me lawyer Jonathan Akope. I would want lawyer to introduce himself, and then we can begin this discussion. Lawyer, so if you can hear me, kindly unmute your device and then introduce yourself. My name is 𝐀𝐝𝐦𝐢𝐬𝐢𝐨𝑧. I'm an HR professional, and I have lawyer on the line. Lawyer will do the same. He will introduce himself, and then we'll take it from there. Lawyer, you are welcome.
Thank you very much, 𝐀𝐝𝐻𝐿𝐴. Good afternoon, and good afternoon to your viewers as well. My name is Jonathan Ajope, and I'm an associate with 𝐀𝐝𝐦𝐬𝐢𝐬𝐢𝐨𝑧 & Associates. We are a law firm based in Community 8, Tema. I work with the firm as an associate, like I said. I work on especially HR-related issues, termination, normally representing employees who feel aggrieved by some employer related to employment termination issues. I also work on real estate, and I do some criminal law as well. So that will be my way of introduction.
All right, lawyer, thank you so much for that introduction. Once again, you are welcome. We also want to acknowledge the presence of our participants from across the nation. Thank you so much for always making time to be a part of this insightful discussion. Um, Again, we want to bring to your remembrance that this program is brought to you by CDAT Consult. CDAT Consult is into various consulting services in HR and a whole host of areas. Now, in terms of HR, you are looking at recruitment, L&D programs, you are looking at employee engagement, you are looking at performance management, you are looking at labor laws and regulations, you are looking at all the areas of HR. You don't have to look elsewhere. Just call CDAT Consult, and CDAT will sort you out with regards to all your HR consulting needs. We also want to acknowledge the CEO of CDAT HR Consult, Patricia. Patricia, thank you so much for putting this together and for bringing all of us in the HR space and beyond together so that we can always share our knowledge in the space. All right. See that HR consult is also organizing a session. The technical team, if you can help us with that, is organizing a conference in Kumasi. See that HR conference in Kumasi. This program is coming up on 26th. Yes, 26th. Let me confirm the date. Yes, 26th of September, Thursday, 26th of September. Recently, we had to launch um, the HR Digest program, and it was very beautiful. You would want to be a part of this. You get the opportunity to connect with various people from the HR space and beyond, CEOs, etc. So it's a Master 10 training, it's a Master 10 conference, HR conference, and it's happening in Kumasi on 26th of September at Makeling Hotel. Yes, we begin from 9 o'clock a.m. to about 4 p.m. It's a whole day program, and like I said, you get the opportunity to hear so much about what is happening in the HR space. Not only that, but also to connect with CEOs and HR professionals with so many years of experience, and then that becomes your advantage. That's very important. So, see that HR conference 2024 in Kumasi is happening in Kumasi. The price tag is just 150 Ghana cedis, and then we have a whole host of things for you. And then there is also a training program upcoming on the laws on employment termination. This program is being facilitated by our lawyer who is connected today. So today you get to hear a glimpse of some of what the law says concerning employee relations, concerning termination. Lawyer Jonathan will be facilitating that session on the laws on employment termination in Ghana. The price tag is very cheap. It's just 1,250 Ghana cedis. And the program will happen at the CDAT conference room around the Amiche. If you have any challenge locating the location, it's easy. Just call CDAT on 0244 629245. Please ensure that you register for this program. It's happening on 14th September 2024, and it promises to be very, very, very insightful. You don't want to miss this program. Now, again, those of you who just connected, we are talking about employment laws on termination today. And I have on the call with me lawyer Jonathan Akope. Lawyer will be doing justice to this discussion. He will tell us what the law says about termination. There are instances where you hear CEOs or owners of businesses, they feel like I have set up my business. I have the right to do whatever I want to do. I can equally say that I won't work with you again. I'm tired of working with you, or I want to do away with you, and come up with a whole lot of decisions that borders around termination. But these are areas that is an area that is very critical, and as an employer, you need to know. As an HR professional, you need to know so that you don't go against what the law says, because there is punishment for going against the law in this discussion. So lawyer will be helping us in all of these areas for us to properly understand what we have to do, so that we don't just make a decision that I employed you and I want to do away with you, not following the rules, what the law says, and all of that. So lawyer, we can begin our discussion. Our first question is that we want to find out what are the legal grounds for terminating an employee under the Ghanaian labor law? What are the grounds, the legal grounds for that matter? I think you are muted. We can't hear you, so if you can unmute your device.
Sorry about that. So I was saying that, as you said in your introduction, one of the things that we tend to take for granted in Ghana is that we normally think that the laws do not work. But that is a very, very wrong perception to have, because again, I tell people that you will only know that the laws work and that they actually bite when you find yourself in conflict with the law.
Absolutely.
When it comes to issues of employment termination, there are laws that govern such. Generally, employees and employers' rights are governed by Ghana's Labor Act 2003, Act 651. Anyone who's been in the HR space for a while now will definitely be aware of Act 651. It's, for me, like the Bible for every HR professional. Now, in Ghana, aside from the various statutes being the acts of parliament, we also have case law. If there are any, case law usually closes the gap where the promulgators of the law are unable to make provisions. So we have Act 651, and then we also have case law, which are decided decisions by Ghanaian courts, especially the High Courts, the Court of Appeal, and then the Supreme Court. Then, when it comes to the legal grounds for terminating an employee under Ghanaian labor law, we will then first look towards what the Act says, that is Act 651. Now, when you go to Section 15 of Act 651, that section is actually titled Grounds for Termination of Employment. In Section 15, you will get to find what are the quote-unquote allowable grounds for terminating an employment of an employee. Now, I may want to read a bit of Section 15 of Act 651. It reads that a contract of employment may be terminated A, by mutual agreement between the employer and the worker. So, and termination of the employment of the employee could be as a result of you, the employer, sitting down with the employee and actually coming to that mutual agreement that, look, maybe my business is not going too well. The employee may also be aware of that fact. And so when you come to that mutual agreement, whatever the mutual agreement is, the court would uphold them. If it ever so happens that any of the parties should proceed to court by whatever reason, but by mutual agreement between the employer and the employee, it's one of the grounds for terminating an employee's employment. The second is...
Can I interrupt briefly? Just
that's okay.
Clear on just to be clear about the first point. So where there is mutual agreement, then there can be that separation or termination can happen. Now I want to find out, should there be any documentation to this effect so that the employee doesn't go to stand somewhere to say that we didn't agree, there was no mutual agreement, so what will be the basis?
Absolutely, there has to be some documented, some document to the effect that so and so sat down with so and so on this day, and we agreed on so and so. So if you have that written, and then maybe it could so happen that the company is not doing too well. There was a decided case, I've forgotten the case title, but there was a decided case where an entity wasn't doing too well, and he decided to, on mutual grounds, come to an agreement with one of the employees, actually it was a number of them, to terminate the employee's employment. Now, the employer had actually made certain, will I call them promises, or had actually stated certain things that they were going to do for the employees upon the termination of the employment of the employees. So the employees left their employment, They were expecting that within 3 months or so, that per the document or per the agreement, they had agreed that the employer was going to get whatever package that they had promised the employees. Unfortunately, after the 3 months, the employer couldn't get those promises through. So, on the basis of that agreement, the employees went to court. And of course, the court upheld whatever the mutual agreement was, because the court is very protective of any agreement that two people of the right age, of sound mind, as long as there are no grounds of undue pressure or influence or coercion, as long as it's by the free will of the parties who come to make that mutual agreement, the courts are mandated, as long as there is no fraud or illegality, to uphold such a mutual agreement. So, advisedly, I would advise any day that such agreement should be documented in case of any, pull it out as your evidence in any court of law.
Absolutely.
Okay. Now, on the second point is that by the worker on grounds of ill treatment or even sexual harassment. So, if there is any boss in the employment of the employee who is sexually harassing or ill treating the employee on those grounds of ill treatment or sexual harassment can actually bring the employment relationship to an end. Then the third point is by the employer on the death of the worker before the expiration of the period of employment. So one of the things that we ought to come to terms with, especially for employees, is the fact that employment cannot be transferred. The fact that I'm an associate with 𝐀𝐝𝐦𝐬𝐬𝐢𝐨 and Associates doesn't mean that I can transfer that to my children. It's not like business shares that I can actually transfer to my children, but employment cannot be transferred. So once I pass, that employment relationship automatically comes to an end. Even if we had a 5-year contract and we are 2 years into the contract and I pass, the fact that there are 3 years left on the contract doesn't mean that that can actually be transferred to, say, my children. If maybe in my will, I have willed every property of mine to my children. Employment cannot be a subject of transfer in a will or any such. Then the fourth ground is by the employer if the worker is found on medical examination to be unfit for employment. And this is one of the reasons why employers usually institute medical examination as part of the preliminary grounds for why they should employ you. You may have passed your interview, you may have passed whatever exams you need to write. However, if you do not pass the medical examination, then by virtue of that, and the reason this is a good grounds is that more often than not, the employee would have begun the work for a few days, sometimes even weeks before the medical examination comes in. But if on the basis of the medical examination, yes, you've been given even a probation, and then you are found to be unfit by reason of the medical examination having been examined by an accredited medical officer or director in Ghana here, then on the basis of you not being medically fit, your employment can actually be terminated.
Yeah, lawyer,
Then,
that's so. There's an example, and then the practice in the HR space. Let me
right,
quickly interrupt. So for some organizations, they even have policy around prolonged sickness. So what will
yeah,
happen is that they would give a first 3 months full salary to the employee. This is in the area of prolonged sickness. So they would say that for the first 3 months of such circumstance, the employee will be paid the full salary. Then
right,
the next 3 months, the employer says that I can do half of your salary. Then
right,
after the 6th month, so from the 7th to the 9th month, the employee says that you will be on no salary. And then from
right,
that time, if the employee is still not well, then the process of offboarding is initiated. So,
right,
just like you indicated on grounds of medical health, I just wanted to give an example
right,
for our listeners to be clear. So there is an instance where you are now coming into the employment, and then the employer thinks that you are not medically fit. So that they don't even engage you at all. Then you have also come into the employment, and then we realize that you are not medically fit. I have found myself in an environment where a team member um, was no longer fit. The
Right.
person was diagnosed with stroke, and then that policy was activated for that person. So the very first 3 months, the employee is on full salary. Then after the first 3 months, that half salary is activated. Then after that time, if
Right.
the employee is still not well, then the third level bit of the policy is activated. Then after that, if nothing is happening, then the employer says that, look, I can no longer, keep you in my space. I've tried. First 6 months, something has been done. We still gave you 3 months for you to recover. We are still not seeing anything. So after the ninth month, at least we can begin the process of board. I just wanted to use that example to clarify
Right.
what
Thank
you
you very
said.
much.
Law.
However, just to clarify,
Hmm.
when we are talking about ill health here, we would have to distinguish between ill health as a result of it not being connected to the work. For
Okay.
example, if someone finds him or herself in a chemical processing space
Hmm.
and they take ill as a result of as a direct result of the work.
Yeah.
Now you are not going to be able to kick that in because the person is medically unfit, yes, but as a result of the work. So
Exactly.
this is where the workman compensation sets
Come.
in.
Yeah.
Where yes, it is true that the person is medically unfit.
Hmm.
In your case, you are saying that he suffered stroke. So I want to believe that it wasn't as a direct consequence of the work. It
Hmm.
was his own medical condition that had
Yeah.
nothing to do with the work. So in
Yeah.
that case, that policy would work. And
Yeah.
and it's always good that such a policy is contained or at least mention of it is made in
Hmm.
the contract of employment at the very beginning.
Yeah. Absolutely.
The whole employment regime whilst they are on employment with them with the employer. Now, if the person gets injured or gets medically unfit as a result of or as a direct result of the work, then that becomes a whole different game. Because I am dealing with two cases now where
Hmm.
there are two people who got badly injured on a job. One of the machines at the workplace actually injured them. So yes, you can medically they were unfit for the kind of work that they were employed to do. However, under the Workmen Compensation Act, the employer is mandated to pay the full salary of the employee throughout the period that the employee is unfit.
Yeah.
So now it becomes a bit separated from the situation that you actually made mention of.
Yeah. So then it means that the medical doctor's report must also come into play to decide or to determine
Exactly.
rather the cause of the sick.
That is correct.
Absolutely.
That is correct.
Absolutely.
That is correct. So the medical examination is supposed to make mention clearly of
Mm.
whether this injury or this medical condition this person is suffering
Mm.
is as a direct consequence of the work. If
Absolutely.
that is so, then the Workmen Compensation Act sets in. If that is not so, then of course the policy that you are making mention of could actually set in. But I always prefer that such information is made known to the employee from the onset.
Absolutely.
Yes, it is true that we may not be able to anticipate every condition under the earth, but at least if you've been in the space for a while now, you should be able to know what are the nuances that come in when it comes to employment termination or everything related to employment.
Absolutely.
Then quickly on the fourth ground, or on the fifth ground rather, by the employer because of the inability of the worker to carry out his or her work due to one, sickness or accident.
Mhm.
Two, the incompetence of the worker. And on the incompetence of the worker, it's not about the person not being able to deliver on their deliverables and then you just rush in and say that, hey, you are incompetent and that
Yeah.
we are terminating your employment. There has to be some system put in place. First of all, has the employers or the employees subpar performance been brought to his or her attention?
Yeah.
What were the steps taken by the employer to at least bring the employee to a certain standard? Maybe the employee doesn't have the requisite training for the job
Mm,
that you brought them to do. Have you
yeah.
given them, or have you taken them through such training? If you've
Mm,
taken them through training, and all these have to be documented, so that in case in the future the employee should sue you for maybe wrongful termination or for unfair termination, you have all these things to tender into evidence that, hey, we have done everything, we made him aware, or we have maybe quarterly or biannual or annual performance review. These were his performance reviews for the period. We brought these to his attention. We took him through training A, B, C, D, and
mm,
yet still the employee was still not delivering on their deliverables. Then
absolutely.
on the third point here of proven misconduct of the worker, and this is also where most employers get it wrong. Proven misconduct, not just misconduct, but proven. It has to be proven. There has to be a committee set in place to investigate and give the employee the opportunity to respond if there are any allegations of misconduct.
Mm,
If all that is done and then the employee is found to have misconducted him or herself, then this also sets in as grounds for terminating the employment of the worker. So, in a nutshell, the legal grounds for terminating an employee under Ghanaian law is found in Section 15 of the Labor Act 2003, Act 651.
Lawyer, thank you so much for that explanation and for
So,
that reference as well. So, for those of us connected, you would want to make reference to the document and then the section that he just quoted and shared with us. Now, I have dealt with an example of terminating an employee's contract on the basis of his or her incompetence.
right.
Now, like he said, we should not be in a hurry to want to terminate an employee's contract on the basis of underperformance. If we follow the interventions, you would realize that the employee's performance could come up to speed. And this is what happened. So, for a certain employee I was dealing with, this person had a certain performance challenge.
Mhm.
And so, but the policy document had set it out clearly. First of all, the policy defining the level which you can call an employee, or you can say that an employee is underperforming. That was already defined. So, in the
Right.
performance management system, that is already clearly defined. And then the employee finds himself or herself in that particular range. So, you want to now activate the next level, which we call performance improvement plan. So, that was
Yeah.
activated for that employee. And within the performance improvement plan period, you want to give that employee that attention, interventions to help, you see, because the whole idea of the PMS is to help the employee to even do better, to develop the employee, to
Yes.
help them to do better. So, interventions were provided for the employee, and within a space of 3 months, the gaps that were identified, for which reason she found herself within the PIP, she found herself within that range, and PIP was activated for her. Within that 3 months, she made a lot of adjustment with the support from management, and
Great.
uh, she was off that program and she began doing well in that particular area. So it's important that we are not in a hurry to want to terminate an employee's performance.
That's
And then
excellent. That's very
law also defined termination clearly. We also want to emphasize that termination, as we are talking about, does not necessarily mean the employer exiting the employee, but on both levels. So the employee could also choose to exit, while the employer must also follow the guidelines of the law and the policy document to also want to exit an employee. So it's both ways. And I needed
that's
to
correct.
re-echo that. Thank you so much, lawyer. Please, those of us connected, you can share your questions in the chat box. We'll read it out to lawyer to give us the responses for those questions. Well, so my second question is that someone is watching and he wants to know, or she wants to know, what procedures must an employer follow before terminating an employee?
Thank you very much for that question. Now, when it comes to what procedures must be followed, usually such procedures ideally have to be contained in the employment letter regulating the employment relationship between the employee and the employer. And more often than not, this is where a lot of HR professionals get it wrong because usually these contracts of employment are drafted by HR professionals. And by no means am I downplaying the skills and know-how of HR professionals. However, when it comes to the law, there are certain nuances of the law that if you are a non-lawyer, you may not be able to come to terms with because some of us go to court every day. Not only do we handle some of these cases, but of course we go to court to also hear and see other cases of similar nature being handled. When you are drafting, and it's one of the modules we are going to be touching on coming Saturday, on drafting of foolproof contracts of employment. We are going to handle from the very beginning to the very end, what are the elements you need to consider when you are drafting a contract of employment. Now, our experience as lawyers is that most employment terminations are carried out haphazardly. And usually this is because there are no termination clauses contained in the contract of employment. And even where there are termination clauses, they usually do not, HR professionals usually do not go by those termination clauses. Every contract, well drafted, needs to have a termination clause. What are we going to do, or what procedure are we going to follow if we want to bring this contract to an end? Do we have to sit down and negotiate? Do we have to refer the matter to a mediator? Do we have to refer the matter to an arbitrator or whatever it is? Or do we have to refer it to some officer in the company? Is it the supervisor of the employee who has to take over when it comes to employment termination, or the HR manager or whoever? Now, however, when you are bound by a contract, but you contravene a key provision of the contract, like its termination, it could serve as grounds for a suit for unlawful or even wrongful termination. So the procedure in terms of what an employer must follow to terminate an employee's employment is not a one-size-fits-all. It all depends on company policy. It sometimes also depends on what the practice is within that particular industry. But usually it depends on what the termination clause is as contained in the contract of employment regulating the relationship between the employee and the employer. Once there is a termination clause, please make sure that you follow that termination clause whenever, except it is on grounds of summary dismissal, where the employee may have seriously threatened someone's life, where it becomes dangerous to keep the employee on the premises, or the employee may have stolen some money that has been found. Those could be grounds of summary dismissal, where you may not have to activate the termination clause because that may take some time to be done. So there are certain reasons or certain grounds that could be enough for you not to necessarily go through all that long process. However, those have to be grounds for summary dismissal. So like I mentioned, next week, Saturday, it's one of the things that we are going to handle. We are going to go through a whole training of how to draft foolproof contracts of employment, and most importantly, taking care of termination clauses in our contracts of employment.
Thank you very much. We will be going on a commercial break, but let me just take a moment to acknowledge some of our participants. I have Zachary Salamat watching from Kumasi. Good evening, Zachary. Thank you so much for joining. I have Anita connected. Anita says, I'm watching from Accra. Thank you so much, Anita, for joining. We have some questions in the chat box as well. We'll take them. I have Margaret George connected. Margaret, Thank you for joining, and a whole host of participants connected to this session. Let's go for a quick commercial break. When we come back, we'll take more questions and we'll take it from there.
Right.
Tropical storms, flooding, wildfires, drought, shrinking fish catch. In a world of ever-increasing uncertainty, nothing is predictable. The smallest stumble or fumble easily ends in a mighty tumble, with your world crashing down around you. Don't crumble. 𝐀𝐝𝐦𝐢𝐬𝐬𝐢𝐨𝐧 always has your back. 𝐀𝐽𝐶𝐻, we cushion you for life.
All right, welcome back from our commercial break. We earlier announced that CDAD HR conference is coming up in Kumasi. Let me take a moment to acknowledge our sponsors for the HR conference. We have Glyco Life Insurance. Glyco, thank you so much for your sponsorship. Glyco is sponsoring this upcoming program, which is happening on 26th of September. If it's about your insurance policy, don't look anywhere further. Look at Glyco Life Insurance. Look at Glyco. We also have Fiman Rural Bank sponsoring the same program. Fiman Rural Bank, thank you so much for your sponsorship. And then we have Okante Studios. Okante Studios, we appreciate your support. Thank you very much. And then Focal Link Tech, they are also sponsoring this program. So we just want to thank our sponsors for their sponsorship. Thank you, thank you so much for your sponsorship. So moving on, I have Margaret ask that can termination during probation be termed as unfair? Lawyer, if you can take that for us. She's asking that can termination during probation be termed as unfair?
It depends on the grounds. When it comes to unfair termination, there are actually grounds spelled out in Section 63 of Act 651 that constitutes grounds for unfair termination of employment. So, depending on what the grounds are, for example, if you have an employee on board who intends on joining a trade union and you intend on terminating the employee's employment on the basis of he wanting to join a trade union, that could actually constitute grounds for unfair termination, even though he or she, the probation doesn't necessarily give us the license, quote unquote, to do anything. The probation period is not pre-contractual period. In fact, the probation period is part of the contractual period. So the moment there is a contract, everything that could constitute unfair termination, even if the person is 10 years into it, could still constitute grounds for unfair termination if the person began working with you for just a month. Or in another sense, I was with my senior to interview for a clerk for one law firm, and the head of the chamber didn't want to employ this person as a result of the person's religious orientation. Now that could also, assuming that she had already employed the worker and later decides to terminate, then that could also be grounds for unfair termination, even if the said termination was during the probationary period of the employee. So the grounds for terminating, normally the whole probationary period is to check the fit between the employee and then the employer. The employee also has a right within the probationary period to terminate the employment if he or she realizes that no, this employer is not a good fit for me, just as the employer also has that right. So if you terminate the employment of the employee on certain stated grounds, as spelled out in Section 63 of Act 651, they could actually constitute grounds for unfair termination.
Absolutely. Thank you so much, lawyer. So it's not really about the period within which the employee has worked or has been with you. It's about following a
That is
certain
correct.
guideline. So if you are following the
That is,
guideline, then it will not be wrongful to terminate.
that is correct.
I also have 𝐀𝐝𝐦𝐢𝐬𝐬𝐢𝐨𝐧. 𝐀𝐝𝐦𝐢𝐬𝐬𝐢𝐬𝐬𝐢𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬𝐬 much for joining. I have Zachary Salamat asking that, can an employer terminate the appointment of an employee without any reason? Without any
Yes,
reason.
you are not. I mean, under common law, it's not mandatory for an employer to give reason for termination. However, again, when it comes to the contract of employment, one of the things in these cases that um, most employers find themselves on the wrong side of the law is that there usually has to be a certain period of giving notice. So if in the contract of employment it is agreed by the parties, in this case the worker and then the employer, you give a month's notice, or you give 6 months notice, or you give 3 months notice. Even if you are not going to give the worker a reason for why you are terminating their employment, you need to go by the period of notice as spelled out in the contract of employment, or in lieu of which you give the employee salary. So if, for example, I'm working with someone and I want to terminate the worker's employment, I don't necessarily need to give them a reason, but if it's stated in our contract of employment that I need to give 3 month notice, if I do not intend on doing that, then it means that I need to give the worker salary covering the next 3 months. If I do not do that, then that becomes grounds for the employee to institute an action against you in court for unlawful or wrongful termination. It is clear as that. So even though you may not have to give reason, you have to go by whatever period of notice that is contained in the contract of employment, or in lieu of which you pay the employee for whatever period. If it's a month's notice that you're supposed to give, then you pay the employee for an extra month, in addition to whatever benefits that have accrued to them before you actually terminate the employment. So you are not, under common law, obligated to give a reason for termination. However, you have to go by the period of notice. And this has been most often the reason that we have issues regarding employment termination, especially on matters of whether or not to give reason. Don't give reason, but go by the notice period.
All right, lawyer, thank you so much. So, someone would want to ask, doesn't it give the employer the if you like the right to just be terminating people's contract by just paying them 1 month's salary in lieu of notice, and then that's about it?
Well, that could be true, but under common law, this whole employee or employer-employee relationship began on the back of master-servant relationship, all right, where in years past, the servant was said to have, quote unquote, no rights. It is as a result of the intervention of statutes such as Act 651 that there have been certain rights given to workers who are, quote unquote, under the common law many years ago as servants. Now, again, even though you may not give reason, or you are not mandated to give reason, if the employee has reason to believe, in fact, there is a case I am handling at the moment of Yes, the employer actually hid under, he gave a certain, I mean, what you may want to call a reason. But by virtue of some happenings before the termination, it was clear what the reason for the termination was. And this was the fact that our client was requesting that the employer should pay SNIT contribution on behalf of himself and his other colleagues. And so what he did was he rallied his colleagues. They brought in the SNIT officials. They registered all of them. And within that space of time, he and a few of those who were leaders of what you want to call that gang, their employment was terminated. So even though you may not give reason for that, anyone could actually be able to tell from the surrounding circumstances, as we like to say in law, that the reason for terminating the employee's employment was as a result of them requiring you to do something that you are required to do under the law. And so if we are able to prove, so if I'm lawyer for the employee and we go to court and we are able to prove beyond, I mean, on the preponderance of probabilities that my employment or my client's employment was terminated on the back of my client trying to rally his colleagues to get the employer to do what is right, because in years past the employer wasn't actually paying their SNIT contributions. So when he came into the job and over a period of time realized that no, there was nothing of the sort going on, then he decided to rally his colleagues around. Hey, let's go get the SNIT guys to come register us. And then that was reason for why he was terminated. So yes, there may not be a reason given, but if the surrounding circumstances indicate or point to something that may have happened around when you have terminated the employee's employment, we can, if we're able to prove that in court, I mean, you can actually be found liable.
Okay. All right. Thank you. Thank you so much, lawyer. Sewa Asante, thank you for connecting. She's asking a similar question, but what I want to also ask is that um, are there any references with regards to the final feedback you gave? Are there any references from the Labor Act? You spoke about common law. Maybe someone is connected and the person is wondering what is common law. Um, so can you talk to us
Right.
about that? Are there any references from the Labor Act, first of all? And then what
Yes.
is the common law? Because you've mentioned that in common law, you can actually terminate without a reason as an employer. So
Right.
if you can throw some light on that.
So common law is a law we received during the colonial era. During the colonial era, we were under the British government. And so the laws that we received from the British government that were regulating how things were done here is what we call the common law. In fact, the common law is recognized as one of the laws that are in operation in Ghana when you go to Article 11 of Ghana's 1992 Constitution. So basically, these are laws we received from the British as a result of colonization. So even though a good number of those common law positions have been modified, when there is a modification of common law positions by statute, we go by what statute says and not what common law says. But if there are any things that statute or case law doesn't necessarily expressly take care of, then common law still sets in. So common law is basically the laws that we received from the British during the colonial era. So in Africa here, we have countries that still go by certain common law provisions, such as Ghana, the Gambia, Nigeria, and a few other countries. I think Kenya, South
So
Africa has.
are these common laws specifically documented, or they are just
No, they
like
are not. Yes, they are not well documented in the real sense of the word as we have Act 651. No, they are not, because even the British actually have an undocumented constitution. But these are laws that have been decided over as a result of case law. So whatever was the position of the law in case law, these become the laws over the period of time. So if you go way back, These laws were not even promulgated by judges. They were ordinary men and women who had lived in the communities and knew how certain things were done. Just as many, many years ago, we also had our native courts, most often presided over by our chiefs, who were also doing some of these adjudications here and there. However, the problem with our time or our instance was that we didn't have any form of documentation.
Mm.
They had cases that were put in documentary form. So over time, it became predictable how certain issues were handled. So,
Okay.
for example, if something happens between A and B, and then it is decided in the future, if a similar situation should come up between C and D, we refer to what was decided between A and B under similar circumstances to decide what the outcome is between C and D. So these over time become a predictable way of determining the rights between parties, and that is what we call the common law. The common law basically is the law that is at play between the common people then during the monarch period of Great Britain.
Wow. Thank you for that insight. So I was asking that with regards to terminating without a reason, are there any references from the Labor Act?
Please come again.
With regards to terminating without a reason, is there any
Yes.
reference from the Labor Act? Can we make any
From the
reference from
labor, I do not think that there are any express provisions because, in fact, the Labor Act is quiet when it comes to not giving any reason for termination, for employment
Mm,
termination.
mm,
That is the reason why I had to quote the common law position because we do not have an express provision in our Labor Act that
mm.
actually makes mention of that. So that is where common law sets in. But under our Labor Act, there are stated reasons or stated grounds for which a worker's employment should be terminated.
Absolutely. Thank you. I have Alfred Soa on the line. We have just a few more minutes to go. I have Alfred Soa on the in the chat. Alfred is asking that please can an employer terminate the appointment of an employee when they are found redundant?
The whole issue of redundancy also becomes a very slippery ground for many employers. Yes, if there is redundancy, redundancy basically means that by no fault of yours, the worker, there is no business or the business isn't doing well anymore, or there is some form of structural change going on. Let's say, for example, you were working with, for the purposes of example, Airtel and Tigo. And as a result of the amalgamation between Airtel and Tigo, now Airtel Tigo, your role became redundant. It was by no fault of yours. You didn't ask the shareholders or those in charge to go through a structural change. Now, on the basis of you becoming redundant, the employer has to give you a severance package. You need to give your employee as a result of they being redundant by no fault of theirs. However, most employers normally do not go by these redundancy packages that they are supposed to. Or sometimes, even if they do, they may skip it, or they promise and then they do not go by their promises. So, to our pursuer's question of whether or not an employer can terminate the appointment of an employee when they are found redundant, yes, they can terminate your employment as an employee. However, they are supposed to come to terms with you to agree on what is your severance package under the redundancy program. And once both parties come to that agreement, then that agreement becomes binding on both the worker and then the employer, such that if the employer does not uphold whatever is contained in the agreement, it constitutes grounds for the worker to go to court, or normally, if there is already an agreement, then you go to the Labor Commission for them to ensure that the employer upholds their obligation under the agreement.
Thank you so much, lawyer. It looks like this is how far time would allow us to go. Because of that, this coming Saturday, there's a whole session being organized by CIDA Source of Employment Termination. Lawyer will be facilitating that session, and you don't want to miss it. Look, when it comes to the law and HR, there are so many things that you can be looking at, especially as an HR professional. And these are areas that, like he said, many HR professionals would miss, in its application. So it's important that you invest into this particular training program and in this area, so that you can be very, very well abreast with the area, and even advise your employers in this particular area, because sometimes you find employers also more or less forcing their HR people to activate a certain decision without recourse to the law and all of that. But if you don't even know your position and the position of the law as an HR professional, then you also find yourself taking a particular decision that puts a dent on your profession. So it's important you register for this particular training program. It is happening on the 14th of September, this coming Saturday. Just contact CDAT Consults and you'll be good to go. And then also we spoke about the CDAT HR conference 2024, which is happening in Kumasi on the 26th of September, Thursday, 26th of September. It is very, very cheap. It's just 150 cedis. The benefits are enormous. You get to network, you get to have so much information come to you as a result of knowledge sharing, and you don't want to miss this program. So we want to thank our viewers so much. Viewers, this is how far we can go, like I mentioned. We want to thank you so much for connecting to our session today, being a part of it, and for asking your questions. Very important and was very engaging. And so we thank you so much. Again, we want to thank CDAT Consult for putting this together, and all the people working at the background, the ICT team and all of that, to ensure that we are able to come live and to have this program beautifully. Thank you very much, everyone, for joining. We appreciate your time, and we'll see you again. Until then, it's bye-bye for now.
My name is Patricia Vnakisi. I'm the CEO of CDAT Consult Limited, the organizers of the CDAT HR conference. I'm so happy that we are having this conference, especially in Kumasi. And as CDAT Consult, as a company, we are committed to knowledge sharing, creating opportunity for networking, and ensuring that people in the HR profession advance in their careers. That is why we put together this conference, to give the opportunity to our HR practitioners to first of all learn about the new trends in the HR space, learn about how we can be innovative and creative in ensuring that we are impacting the organization. A lot of the times, HRs are seen as cost centers, but we want to change the narrative. And if we can do that, we need to be very creative. We need to also ensure that we are leveraging on technology to be able to impact or determine or demonstrate how we are contributing to the bottom line. In this dynamic landscape of human resources, we have gathered here together to explore the most pressing trends, challenges, and the opportunities. We know that HR has evolved, and we also know that technology has enabled us to evolve. And so if we don't embrace technology, it's going to be very difficult for us.